Stanley Campbell from Rockford Urban Ministries here in Rockford, Illinois. Dorothy Reddick is actively leading the charge on this issue here. And we certainly are hearing quite a bit from the local state's attorney against this Pretrial Fairness Act. And so we hope and pray that we can get enough information to counter the misquotes and stuff.
Good evening, everyone. My name is Sarah Stout. I'm the Director of Policy at Chicago Appleseed Center for Fair Courts, which is one of the member organizations of the Illinois Network for Pretrial Justice. Rockford Urban Ministries is also one of our members. I'm here tonight to talk about the Pretrial Fairness Act, why, how it was conceived, what led to its passage, and what's in it. So that we can have a really honest discussion about what the Pretrial Fairness Act means for Winnebago County. So I'm going to go through a couple things. We're going to talk first about who the Illinois Network for Pretrial Justice actually is, and then we're going to talk a little about the impacts of money bond and pretrial incarceration throughout Illinois. We're going to talk about how the system works right now, and then spend the bulk of the time talking about the Pretrial Fairness Act. We're then going to talk a little bit about how the Pretrial Fairness Act makes our communities safer and why we passed the bill the way that we did and why the bill does what it does. We'll talk a little bit about what some of the challenges we're facing right now are and how you can get involved. And at the end, we'll have some time for questions. So the Illinois Network for Pretrial Justice is a network of over 40 organizations from around the state. Groups have been working on the end of money bond for almost a decade now. And the Illinois Network for Pretrial Justice itself was founded in 2019 to really bring a statewide perspective to the conversation. Obviously, this is not just a Cook County issue. It's not just an urban issue. It's not just a rural issue. It's an issue that affects every single person in Illinois. And so we wanted to make sure that we had a network of organizations that really represented the whole state. We have members all over the state. We obviously have members in Rockford, Springfield, McLean County, Peoria, Chicago, all over the place. If you look here, these are some pictures from back when it was easier to gather in person. Some of our in-person gatherings and our lobby day down in Springfield back in 2020, beginning of 2020. It's been a wonderful network of groups who come from a really diverse set of perspectives who have worked together to make the end of money bond a reality. Okay, next slide. So let's talk a little bit about what money bond is and what its effect is in Illinois. So there are 91 jails across Illinois' 102 counties, and there are more than 250,000 people who move through those jails every year. Most of them, more than 90%, are incarcerated pre-trial, which means they haven't been convicted of a crime. They've been arrested, but there's been no trial and there's been no guilty plea to show that they've actually been convicted of what they're accused of. But more than 90% of the people in our jails, that's the situation that they're in. They're in jails because of accusations. Most of the people who are sitting in our jails pre-trial are incarcerated only because they can't afford to pay a money bond to get out of jail. Next slide. So let's talk about how the system works right now. Basically, what a money bond is the price that's placed on your freedom. The way the system works right now is that after you are arrested, charged, and booked for a crime, you go to a bond hearing. And at that bond hearing, a judge makes one of 4 decisions, but that three outcomes in my different colors here. The first is that they can release you on what's often called an I bond or a recognizance bond. That means that you can go home without paying any money. On that's sort of the easiest end of the spectrum in terms of getting out of jail. On the hardest end of the spectrum, you can be totally denied bail. The state's attorney, the prosecutor, can file a motion and say, Because of public safety reasons, we believe this person should be held in jail without the opportunity to post bail, and you can be incarcerated pre-trial. But the majority of people, and particularly the majority of people in Winnebago County, are given a money bond, which means that there's an amount of money they're told it is safe for you to go home. And a judge makes a finding that it's okay and safe for a person to go home, but you can only go home if you can pay a certain amount of money. And as a result, there are two different outcomes. For people who can afford money bond, they get to go home. But for people who can't, they end up incarcerated in jail. Next slide. So one of the things that really is the primary impetus behind the Pretrial Fairness Act is everything that we know from talking to communities, from research about just how harmful pretrial incarceration is. Incarcerating someone pretrial, putting them in a cage, away from their family, away from their communities, is one of the most harmful things that we can really do to a person in society. We know that even 24 hours, even less, but particularly even 24 hours of time in custody can cause people to have worse outcomes in almost every area of their life. It can cause people to lose their employment. It can cause them to lose custody of their children. It can cause them to lose access to housing. And in the long run, it destabilizes people's lives so much that people who have spent time in jail often, just because they were in jail, end up in the long run actually being more likely to be involved in the criminal legal system in the future. So we're sort of shooting ourselves in the foot when we incarcerate people pre-trial. Jail leads to increased crime, and that is one of the major reasons why we want to make sure that as few people are jailed as is humanly possible. Pretrial freedom matters. Pretrial incarceration not only destabilizes people's lives, it also destabilizes our justice system. Pretrial incarceration creates convictions. People who are incarcerated pretrial are 4 times more likely to be sentenced to jail, 3 times more likely to be sentenced to prison, and their sentences are longer, 2 times to 3 times longer. It also increases, as I said, the likelihood of future arrest, not only so both in the short term and the long term. And the longer people spend in pretrial incarceration, the more the risk of future rearrest increases. What we're going to do now is listen to a video to hear from some directly impacted people about how money bond impacted their lives.
I was incarcerated pre-trial for 2 months.
2 months,
3 months,
1.5 years.
simply because I couldn't afford to pay $1,500.
$5,000.
$7,500.
$25,000.
I lost my home.
I nearly lost my son.
I lost my business.
I almost took a plea that I wouldn't have otherwise.
Not because of a conviction.
But because of an accusation.
Our stories are unfortunately not unique.
They are all too normal.
Every year, more than 250,000 people pass through Illinois' jails.
250,000 people.
But we can stop this injustice today.
The Pretrial Fairness Act will end money bail in Illinois.
The Pretrial Fairness Act will restore the presumption of innocence.
The Pretrial Fairness Act will allow hundreds of thousands of people per year to stay in their communities.
Working,
Taking care of their families.
And accessing services while awaiting trial.
let's end money bail.
Let's end money bail.
Let's end money bail.
Let's end money bail.
And bring our people home.
Across Illinois.
So stories like the ones we just heard are the reason that the Pretrial Fairness Act was conceived of and eventually passed. It was incredibly important that the experiences of people who had gone through the justice system really shaped the way that this law came into being. And legislators and activists and policy experts from all across the state worked together to make this bill a reality. What I'm going to do now is I'm going to walk through some of the principles that guided how the Pretrial Fairness Act works. And in doing so, I'll actually walk through the actual process that will take place after January 1st when someone is arrested, and what process will replace that money bond process I talked about earlier. So you can go to the next slide, Matt. So the first and sort of the principle that everybody knows about the Pretrial Fairness Act is that money should never be a determining factor in whether someone is free or jailed pretrial. What the law does is it ends all use of money bond everywhere in Illinois for every kind of charge. This makes Illinois a progressive pioneer in the United States. We are the first state to fully end money bond. And that is something that we should be incredibly proud of. Money bond causes a huge amount of harm. And as many other states have moved towards also decreasing their use of money bond, we can be proud to say that we're the first state to have fully ended the practice. This second principle is the most important principle, and the one that I'm going to spend the most time on. That principle is that release should be the norm and detention the carefully limited exception. If that sounds like legalese, it's because it is. This sentence actually comes from a U.S. Supreme Court case. It's called U.S. versus Salerno that was ruled on back in the 80s. And it's actually Chief Justice Rehnquist, so a conservative justice, said is that the way our justice system is supposed to work in America is that you're supposed to be innocent until proven guilty. And that means that an accusation in the vast majority of cases should not be enough to place you in jail. We should only be using jail when there is no other option. This carefully limited exception to the general rule that until you're convicted of a crime, you shouldn't be punished for it. So the Pretrial Fairness Act, throughout the sort of the life of a case, makes sure that people are more likely to be released than they are right now, and that their release is dependent on carefully considered factors that judges take into account, as opposed to the really haphazard money bond system that we currently have, where it's the size of your bank account, not any sort of rational factor that really determines whether or not you're in jail. So the Pretrial Fairness Act does this in a couple ways. The first thing that it does is that it requires police to ticket instead of arrest for minor charges and allows release from police custody. There's a big exception to this that I think is important to talk about because of all the misinformation that's been going around. What the Pretrial Fairness Act is trying to do is encourage police in all circumstances where it's safe and possible to issue a ticket rather than arresting somebody for minor charges. We're talking things like traffic offenses and drinking on a public way. If the police do believe that there's a threat to the community, or if they believe that someone is a threat to their own safety or the safety of another person, they still have the ability to arrest, and the police have the sole discretion to determine whether that risk exists. So the Pretrial Fairness Act doesn't actually change the power of officers to arrest, but it does encourage them that where possible, they should issue tickets instead of arresting people. The reason that's important is that we want to stop people from spending time in custody as early in the process as possible, especially for extremely minor cases, which ultimately are not going to end up leading to jail long term and are usually going to end in a fine or just a dismissal of the case. The second thing that the Pretrial Fairness Act does is it raises the standard required to incarcerate people pretrial. That's not hard to do because right now the standard to incarcerate people pretrial is really just based on whether you have money. Judges don't make careful determinations a lot of the time on whether or not someone poses a threat or is likely to flee the jurisdiction, or basically a finding that there's a good reason to hold someone in custody under the current system. Instead, they set a monetary amount, and whether or not the person has money is what really determines whether they spend time in jail. So the Pretrial Fairness Act raises those standards and has a set of findings that judges need to make if they're going to hold someone in jail. The last thing that the Pretrial Fairness Act does is it creates what we call a detention eligibility net that requires release for many people who are arrested. there's been a lot of conversation around this issue. And one of the things that's been circulating is a list of very serious charges where there's a claim that somehow release is mandated under the Pretrial Fairness Act. And those claims are false. The Pretrial Fairness Act allows judges to detain people in custody for serious charges. But most people who are arrested in Illinois are arrested for relatively minor offenses. And for minor offenses, the Pretrial Fairness Act says, unless you're already on release for another charge, or you're on probation or parole, you deserve to have a fair shot to go back into your community and succeed pre-trial. And most people who go home pre-trial will succeed. And I'm going to get to this later, but in fact, an extremely, extremely small percentage of people cause any major problems in their communities when they're at home. So under the pretrial, actually, Matt, yeah, you can go to the next one. So under the Pretrial Fairness Act, the court has to be able to prove three things before incarcerating someone pre-trial. The first thing, something they already have to prove right now, is that there's probable cause that the person committed a qualifying offense. The second thing they need to prove is one of two things. Either that the person poses a specific, real, and present threat to the safety of another person, or that they're highly likely to willfully flee the jurisdiction. That standard is intentionally higher than just, we think it's likely that people are going to miss court, because we know that sometimes people miss court for reasons that are beyond their control. But if the prosecutor has reason to believe that the person is likely to really evade prosecution, the person can be held in custody. The last finding that the judge has to make is really meant to effectuate that release is the norm, and detention is the limited exception idea, which is that the judge needs to find that there's no conditions other than detention that will protect the public from that threat or prevent the person from willfully fleeing prosecution. So jail needs to be the only option on the table, the only thing that the court believes will really keep everyone safe and make sure that the person doesn't willfully flee the jurisdiction. This is, for those of you who are a little bit more visual, a sort of very, very simplified explanation of how the Pretrial Fairness Act works. And the thing that you can sort of see from looking at it is that there are more paths that are green. There are more paths out of the system and back into communities than there are paths to be detained. So at multiple different points in the system sort of has the opportunity to say, this person doesn't need to be held in custody. They don't need to be jailed, and it's time for them to go home. So when the people are stopped by police, they can be cited or released. They can also be arrested, charged, and booked. After they're arrested, charged, and booked, police can still release them from police custody. For the people who don't get released from police custody, they'll go before a judge the next day for a hearing that really resembles what we currently call bond court. And we're calling it either initial appearance court or a pretrial release conditions hearing, or just a conditions hearing. The purpose of that hearing is one of two things. For most people, the people who are going to go home, the purpose of that hearing is to determine what conditions a judge is going to set on that release. For example, are they going to be required to report to a pretrial services officer? Are they going to be required to participate in an electronic monitoring program? What other kinds of conditions are going to be placed on their release? And I'll talk a little bit more about that later. Most people will be released with conditions. At that hearing is also the time that a prosecutor can request that someone be jailed. And if they do, the case moves on to a different kind of hearing called a detention hearing. At that detention hearing, a judge makes the decisions that I just explained. And if they find that there's probable cause to believe the person committed an offense, that there's a specific real and present threat to another person, or a high likelihood of willful flight, and that there's no other condition or set of conditions that can assure the safety of other people and that someone will appear in court, the person can be held in custody. If the judge finds that one of those things isn't true, the person is released, and the judge can set conditions of release just like they could at the conditions hearing that would have happened maybe the day before. So that's the basic overview of how the Pretrial Fairness Act works and what the system is going to look like. I'm going to talk more now about some of the principles guided the way that it was originally put together. The third sort of overarching principle is the idea that accused people should be viewed holistically. It includes the idea that risk assessments shouldn't be used as substitutes for individualized decision making. Risk assessments are algorithms. They're formulas where a bunch of information about a person is put into a formula and a risk score is sort of spat out the other side. Sometimes that risk score gives a risk of somebody not appearing in court and a risk of somebody getting rearrested. Sometimes it just spits out one number that's on a scale that says this is how risky we think someone's release is. The problem is those are extremely simplified ways of talking about people. And what we know is that they can bake in racial bias. So because most risk assessments rely primarily on things like arrest records, as well as sometimes other factors that are tied to that have racial disparities baked into them, things like employment rates, where we know that the unemployment rate is significantly higher for Black Illinoisans than it is for white Illinoisans, for example. Using those factors can mean that the score basically will often or always say that people of color have a higher risk level than white people, and that's simply not true. So what we need is to make sure that accused people are viewed holistically. So what the bill does is it makes sure that risk assessment tools cannot be the only determining factor in a decision, and that instead that there are a number of other factors, including people's ties to the community, their family situation, and lots of other factors that are brought into account to make the decision about what conditions someone should be released on and whether they should be jailed. It also gives attorneys more opportunity to actually look at what's going on inside those risk assessments and challenge it if they feel that that's necessary. The last thing that the Pretrial Fairness Act does in this arena is it stops nearly missing court from being used as evidence of flight risk in the future. So it differentiates between missing court, which usually happens because people either forget to go to court, just like you forget to go to your hair appointment or your dentist appointment, or because they don't have transportation to get to court. And it differentiates those simple non-appearances from cases where somebody has actually made an effort to avoid prosecution in the past. The fourth principle that I want to talk about is an idea that courts should really help accused people attend court hearings and should restrain their freedom as little as possible while they are legally innocent and awaiting trial. So what the law does is it first reforms the warrant process. It gives judges an option. They still have the option to issue a warrant if someone fails to appear in court or if somebody fails to comply with conditions of pretrial release. But they also have the option of not issuing a warrant. And instead of issuing a notice to somebody to basically say, hey, you didn't show up at court, please come back to court and fix the problem so that we don't have to issue a warrant for your arrest in the future. What this is ultimately going to do is decrease the number of people who are walking around Illinois with open warrants for court dates that they missed, that often they don't even know they missed. And what those warrants lead to is to people being sort of scooped out of their lives and arrested when it's really not necessary. So we want courts to be helping people appear in court, not punishing them for example, not having the resources to get to court and do what they need to do. The law also reforms electronic monitoring programs. Electronic monitoring programs are any program that has somebody wear a shackle or some other device that tracks their movement and restricts them, and often restricts them, for example, to having to stay in their home, sometimes 24/7. Go to the next one. I'll talk some more about EM. So the Pretrial Fairness Act reforms some issues with electronic monitoring. Electronic monitoring is really the most severe kind of supervision, short of jail, that courts can impose on someone. And in most places in Illinois, it's required that people actually stay within their homes 24/7. So they're on house arrest and they're essentially incarcerated within their own homes. We don't see it as an alternative to incarceration. We see it as another form of incarceration. And so because of how restrictive electronic monitoring is, the Pretrial Fairness Act puts some specific rules around it. It requires judges to reconsider electronic monitoring every 60 days. It requires that accused people be given movement, which is permission to leave their homes to do essential tasks. In a lot of places in Illinois, this is already happening because there's a case manager who basically says, yes, you can go do your laundry, or yes, you can go to the grocery store to buy food. But in some places in Illinois, it wasn't happening. And so the law guarantees now that people have the ability to meet their basic needs. It also prevents people on electronic monitoring from being charged with new felony charges for minor violations of electronic monitoring. So, for example, there were under the previous law, people sometimes picked up new class 3 felony charges, so felony charges that carry somewhere between 2 and 5 years in prison, for sometimes violations as small as taking out the garbage, because any violation, no matter how small, of electronic monitoring was not just grounds for you being reincarcerated, but was also grounds for a whole new felony charge. So the Pretrial Fairness Act doesn't change the ability of courts to reincarcerate people who violate the terms of their electronic monitoring, but it does limit the number of new felony charges that can be heaped on top of somebody based on very minor violations. And then the last thing is something that was happening in some parts of Illinois and not in other parts of Illinois. Like I said, house arrest and electronic monitoring usually is used for house arrest is really another form of incarceration. And so the Pretrial Fairness Act makes sure that that's how it's treated by the law, and that people are given credit towards an eventual prison sentence for the days that they spend on electronic monitoring, just like they would get credit for the days that they spend in jail pretrial. The fifth principle is the idea that people who are released pretrial should be treated fairly if they violate the conditions of their pretrial release. Most people who are released pretrial conform to all of the requirements of pretrial release, appear at all of their court dates, and have absolutely no problems. But there will be some people who, whether willfully or not willfully, do fail to comply with the terms that the court has set out, either by getting rearrested or by violating what we call technical conditions, things like reporting to a pretrial officer. Right now, almost any violation of pretrial release, whether it's a new arrest or something more minor like missing a meeting with a probation officer, can be treated the same way. It can be grounds for you to be incarcerated all the way until trial. And there are lots of people sitting in Illinois jails right now who are charged with relatively minor charges and then missed a court date or missed a date with a pretrial services officer, and as a result are sitting in jail when they really don't need to be there. So what the Pretrial Fairness Act does is it reforms the process for determining violations of pretrial release. It makes sure that there has to be a finding that the violation of pretrial release was willful, and it makes sure that that people get a fair hearing before that they're held in custody for a violation of pretrial release. It also disallows permanent revocation of pretrial release for most minor violations. So for people who miss court, or who miss a meeting with a pretrial officer, or who experience a rearrest for something minor, like drinking on a public way is always my go-to example of the sort of common low-level arrest. For those kinds of violations, incarceration is on the table, but judges are capped at incarcerating people for only a month, so that people aren't spending sometimes months or years waiting for trial based solely on a relatively small violation of the conditions of their release. And the last principle is that pretrial practices should be transparent and accountable. The law creates a statewide data collection and publication process. This is incredibly important. I'm a researcher, so this is particularly important to me. Right now, practically every Illinois county keeps data about their pretrial systems in a totally different way. They have different websites and different databases, and none of those databases talk to each other. And as a result, we don't know as much as we should about how people are doing when they're released pretrial, how successful they're being, what court programs work and which ones don't. And so without that data, we really can't make good policy. So the Pretrial Fairness Act requires that there be a statewide system to collect pretrial data and make sure that the public has access to that data. So let's talk a little bit about safety and the Pretrial Fairness Act. This is somewhere where I feel like this is like a part of my presentation that's changed a little bit in the past couple weeks because of how much misinformation there's been about the Pretrial Fairness Act. There's a widespread, there's all of this information out there that claims that the Pretrial Fairness Act will somehow make communities less safe. The people who work to pass the Pretrial Fairness Act passed the Pretrial Fairness Act because they believe, and they have reason to believe, that the Pretrial Fairness Act will make our communities safer. I really mean to drive that home. I truly believe that the Pretrial Fairness Act will not simply make our communities just as safe as they currently are. I believe that it will make our communities safer. And the reasons that it will make our communities safer is because it will keep our communities whole and make sure that our communities have more ability to support the people in them, and that people have more ability to stay stable in their own lives. The Pretrial Fairness Act will ensure that finances no longer determine freedom. Finances are a terrible proxy for safety. Some people who have lots of money pose a huge safety risk. Some people who don't have any money don't pose a safety risk. I think it's fundamentally intuitive that money's not a good proxy for figuring out whether or not there's a safety risk at play. And so the Pretrial Fairness Act makes us safer by creating a more rational system. Reducing incarceration, which is what the Pretrial Fairness Act is aimed to do, also reduces crime in the long run, and it strengthens our communities. What we know from like I said, Illinois is the first state to completely outlaw money bail, but there have been major efforts made across the country to sort of try out the end of money bail. New Jersey almost entirely got rid of its money bail system in 2017, and the District of Columbia and the federal court system, which deals with, of course, some of the most serious charges that anyone is charged with anywhere in the country, have operated without a money bond system since the 80s. There's no evidence in any jurisdiction that reducing or eliminating money bail has caused a rise in crime. In fact, in many places, it seems to be, it has coincided with a drop in crime, and crime has essentially risen and fallen unrelatedly to whether or not there's been a reform enacted. So we have no reason to believe, based on what we know, that getting rid of money bail will cause any rise in crime or any rise in missed court dates, which I think is something that often surprises people. In New Jersey and DC, both states have extremely high rates of court appearance, and New Jersey has been able to maintain those extremely high rates of court appearance after it transitioned from a system that mostly did use money bond to a system that almost entirely does not. One other place that has sort of started the process of decreasing its emphasis on money bond is right here in Illinois, and it's Chicago. Not a lot of people know I think not a lot of people outside Chicago know this about Chicago's bond system, but in 2017, Cook County passed a general order called General Order 18.8A that basically said bonds can no longer be set above what people can afford. Its purpose was essentially to make sure that people were not being held in jail on bonds simply because they didn't have money. That general order eventually led to thousands fewer people being incarcerated in Cook County Jail, and those lower incarceration rates remain to this day. We doubled the number of people that we released pretrial without paying money. Here's what happened. 99.4% of them successfully and safely returned to their communities and were not rearrested for a violent crime. This was even true of people who were rated, remember I talked about those risk assessments, rated as relatively high risk. Between October 2017 and September 2019, 98.7% of the people identified as the highest risk also were not rearrested for a new violent crime and were not charged with a new violent crime while awaiting trial. What basically Cook County's experiment shows is that we can reduce our pretrial jailing populations drastically, and we can maintain extremely high levels of safety. The period of time that we're talking about is a period of time in which crime rates in Chicago continued to drop. And so we know that money bond can be eliminated safely and effectively, and ultimately it will strengthen our communities to do so. Get the next one. So I want to talk a little bit about what some of the things that we're worried about happening after the Pretrial Fairness Act goes into effect are, because what I want to talk about is how y'all can get involved in the work that we do, and understand the larger context of what we're working on. So I'm going to talk about false alternatives to incarceration in a sec, but I actually want to start by talking a little bit about misinformation. I don't have a slide for this, but I think it's incredibly important. If we're going to talk about what we're up against, the biggest thing that we are up against is misinformation about what's in the Pretrial Fairness Act. There are people around the state, and in particular, people from outside of the state, who have a very strong interest in trying to say that the Pretrial Fairness Act does things that it does not do. And it's really, really important that we separate fact from fiction. I hope that you've learned something from what I've talked about today, and there'll be time to ask questions at the end. Once you are armed with this information, I hope you take it back to your communities and your online communities to combat the misinformation that's going around about the Pretrial Fairness Act. The reality is the Pretrial Fairness Act was passed with the effort to make Illinois more safe, and it was passed based on years and years and years of preparation, and actually years of subject matter hearings and other proceedings in the legislature, a Supreme Court commission, and many other steps that studied the effect that ending money bond would have in Illinois, and concluded that it was a good idea that would make us safer. So I really want to make sure that that's the first thing I talk about when I talk about what we're up against, because unless people understand what's actually in the Pretrial Fairness Act and what's not in the Pretrial Fairness Act, we'll have people running around scared of something that we instead think that should make them feel less scared. Another thing that that's fine. I talked about EM already. So one of the things that we want to make sure to keep an eye on as the Pretrial Fairness Act goes into effect is the use of risk assessment tools. I talked about these a little bit earlier, but the Illinois Supreme Court, so to understand, the Pretrial Fairness Act does not require any county in Illinois to use a risk assessment tool that doesn't already use one. We do know that there are some counties, and the Illinois Supreme Court is working on a new risk assessment that they hope to roll out in many Illinois counties. That's very concerning to us, and it's something we want to keep an eye on, because we have a lot of concerns that those kinds of risk assessments could bake in racial bias to this new system that is meant to ultimately be less racially biased than the previous system that was based on money. If we end up with a system that relies too heavily on risk assessment tools, we could end up with a system where racism, which is already baked into many parts of our criminal legal system, is baked directly into our pretrial decision-making systems, and could end up in a situation where we actually increase the racial disparities of people in our jail. So that's something that when you hear about risk assessments, make sure to think about make sure to keep in mind the concerns that exist about those risk assessments using biased information, and ultimately leading to biased outcomes. So now what I want to do, and we'll go to questions in a sec, is to talk a little bit about how you can help. Like I said, the Illinois Network for Pretrial Justice has been working on the Pretrial Fairness Act and working to end money bond in Illinois for years and years now, and we want you to join our movement. There's a lot of different ways you can get involved. A big thing that we're doing right now is combating misinformation, and we want to give everybody as many resources as possible. We also have a ton of events and educational opportunities and videos and all sorts of things coming out in the lead up to the bill's enactment, that you can keep track of and share with other people to help spread the word about what's in the Pretrial Fairness Act. A couple things you can do. Follow us on social media. I know it seems small, but our social media is very active, and we'll give you tons of information about the Pretrial Fairness Act and lots of new material about different parts about the bill. Our Twitter is @endmoneybond, and you can also sign up for our newsletter at endmoneybond.org/news. Raise awareness of pretrial incarceration and money bond in your networks. Take what you learned at this teach-in and talk about it to other people. And also bring us in for a teach-in. We are happy to do this presentation lots of places. We've done it dozens and dozens of times, and we want to do it dozens and dozens more. So please let us know if there's a group of people who would benefit from this message, or just who have questions about the Pretrial Fairness Act and would want to talk to somebody about what's in the bill. Another major way you can help us out is by coming to our lobby day. On November 16th, we are all going to Springfield to meet with legislators about the Pretrial Fairness Act and to help remind them that it's important to stand strong against these misinformation attacks that we've been seeing in the past couple weeks and months, and stand strong and keep the Pretrial Fairness Act in its form as it currently is, and keep it strong so that when it goes into effect, it actually has the results that we intend it to. That lobby day is on November 16th. We are taking buses down to Springfield, and we would love to have you join us. That sign up is, I know, pinned to our social media. So if you go to our Twitter, you should find the sign up sheet right there. And I think that is it. So now I'm very happy to take questions. I know that there are some questions that were already submitted. I'd be happy to, I know Dorothy maybe is going to read those, and I'll take those first. And then if there are any other questions, sorry, I'm just seeing a note that it sounds like maybe we don't have any questions that were submitted ahead of time. So if you have questions, please feel free to drop them in the chat, and I'd be happy to answer them. Hey, Dorothy.
Hey, Sarah, what a wonderful presentation. This is a great segue for many of the questions that have been submitted.
Great.
I tried to categorize them. So let's start with maybe some of the easier questions, I would say, those that are about bond. So the first question is there criteria the judge must look at in order to give bond or no bond?
Well, so the first thing to note is obviously that money bond won't exist under the new system. But in terms of determining whether someone will be... Okay, we've got an echo. I think you're going to have to mute yourself, Dorothy, or move to another room if this is... There we go.
Is it better now?
Yeah, if you just mute yourself when I'm talking, that'll work. So the first thing to understand is that there won't be any bond or no bond in the same way that there is right now under the new system, but there will be release and non-release. And yes, there are factors that judges must consider when they look at whether or not to release somebody. So the law directs judges both to look at things about safety, whether or not someone poses a safety threat to another person. It also directs them to look at things about the person's life that are positive, things like their family connections and their education and their employment, so that we're getting a whole picture of both the person charged and what they're charged with when we make the decision about whether or not someone is going to be held.
Okay, well, you answered the second question. And the next question, you've answered it, but I'm going to ask it anyhow. Can judges still determine a bond for a serious crime?
Yes. So one of the things that's been going around that's been some misinformation is this long list of serious crimes that are claimed to be non-detainable, and it's simply not true. The Pretrial Fairness Act allows for judges to detain people who are charged with serious crimes on one of two criteria. So either that they are charged with, if they are charged with certain kinds of violent crimes and crimes involving guns, that they pose a safety threat to other people, and for all serious crimes that they can make the argument they're going to willfully flee prosecution. And if the prosecution makes that argument, the person is able to be held in custody.
Okay. So I just want to ask a clarifying question, because I know that you just asked us. This person wanted to know if the judge can determine a bond, but it sounds as though what you're saying is that the judge can determine to detain someone.
Right.
But would they still have a bond?
No. So no one will have a money bond. There will be no money bonds, no release on recognizance. We'll really just have two options. Either release, well, really three options. Release with, so you can either detain someone, you can release them with conditions of release that they have to meet in order to stay out of jail, or you can release them with no conditions at all.
So another person wants to know, who's going to be getting this money that's already in bond?
That's a good question. So the short answer is that we don't expect that money bonds that sort of currently set money bonds are going to change all that much after January 1st. The law doesn't state exactly what's going to happen to those money bonds. That's one of the things that's going to be figured out in November when the legislature comes back, most likely. But what we do know is that the money that's currently deposited, what should happen to bond money is that it should mostly be coming back to the people who posted it. And that will happen after the Pretrial Fairness Act goes into effect, just like it happens now.
Oh, wow. Okay. Thank you very much. So these next questions, I'm going to save your favorite question for last, unless you want to do it first.
Whatever works.
Okay, well, I'll save it for last. So one person asked, will this Pretrial Fairness Act make it more dangerous for police in the community?
I don't believe it will. I don't believe it will at all. And frankly, I wouldn't be working on this bill if I did think that. What the Pretrial Fairness Act does in terms of the way that it changes how police interact with people on the street really has to do with crimes where there isn't actually a safety threat. So what the Pretrial Fairness Act basically says is, if there's a safety threat, you can arrest just like you can now. If there isn't a safety threat, so in just those situations where there isn't a safety threat, the law requires that they issue a ticket rather than an arrest when that's possible. So that's really where I think that's the really important thing to talk about when we talk about arrest in the Pretrial Fairness Act. The officer on the street has full discretion to decide if there's a safety threat at play when they're dealing with somebody. And if they believe that there is a safety threat, they have the power to arrest.
Okay, thank you. Our next question is about domestic violence. Will this allow someone who has been arrested for domestic violence or assault to be let out after arrest, which would then give no safety for victims?
So that's actually a really good question that gives me an opportunity to talk about one of the things that I think is the most exciting thing about one of the more exciting things about the Pretrial Fairness Act, which is that it was, part of the conceiving and writing of the bill, and part of and making the bill look like it does right now was done with the express input and support of domestic violence advocates and sexual assault advocates. So the gender-based violence community was directly involved in the drafting and the crafting of this bill. And in the end, the bill has been endorsed by over, I always get the number wrong, but somewhere upwards of 60 domestic violence organizations around the state. The reason that those groups have endorsed the Pretrial Fairness Act is because the Pretrial Fairness Act, they believe the Pretrial Fairness Act is substantially safer for survivors than the system that we have right now. The short answer to your question is no. A person, if you're talking about right after arrest, a person must be held to see a judge before they can be released in a domestic violence case, which actually isn't the case right now. Right now, if police decide that they don't believe that the domestic violence that occurred was serious enough, they have the ability to release someone from the station. That will no longer be true after the Pretrial Fairness Act passes. Well, it has passed after it becomes law on January 1st. Domestic violence is also what we call a detainable charge. It is a charge where detention is available for both safety reasons and for reasons that a person might willfully flee prosecution. So basically what the Pretrial Fairness Act does is it treats domestic violence as a serious crime. It groups it in with other serious crimes and makes sure that it's treated that way, as opposed to under the current system where, because it's a lot of domestic violence is a misdemeanor, it's often grouped in with less serious crimes. The Pretrial Fairness Act changes that grouping entirely and groups domestic violence with serious crimes.
Wow, thank you for that very thorough explanation. The next question is, how does what is being implemented in Illinois differ from what New Jersey implemented?
So it's a good question. Fundamentally, New Jersey implemented its reforms about 4 years ago, and I think that what we've done is really to take what New Jersey did and run with it and improve upon it. Our Supreme Court back in 2018 convened a Supreme Court Commission on Pretrial Practices. And one of the things that that commission did is it reviewed all of the existing laws across the country about bail to try and look at, okay, what works, what doesn't. And one of the things they looked at very, very closely was New Jersey. Most things about the Pretrial Fairness Act and the New Jersey system are very, very similar. There are some differences, primarily because of the way New Jersey is structured as a court system and the way we're structured. New Jersey is like one big county. It has other counties, but its court system operates like one big county. They have one chief judge, they have one prosecutor's office. And as a result, they have a lot more control over the individual decisions that different prosecutors make. So New Jersey is just able to take a approach that's more centralized and sort of relies upon rules that are made within the court to regulate what happens with whether people are released or detained. We've had to write a lot more of those rules into the law itself because we have 102 counties and 102 prosecutors and 102 chief judges. So in general, I would say, one of the places that I would direct you is to if you're interested in like the nitty gritty, is to the Illinois Supreme Court Commission on Pretrial Practices report, because it does a lot to get into the specific differences between New Jersey and us. The other big difference is that New Jersey did actually keep cash bail for certain offenses. So it's not used particularly frequently, but they do still set cash bail. And Illinois took what New Jersey did one step further and said, if we're going to get rid of cash bail, let's get rid of cash bail, and has gotten rid of it in all charges.
Okay, thank you. This is a big question.
Okay.
What crimes have mandatory jail time?
No crimes have mandatory jail time. It's very easy. Every charge needs to be considered individually. That's the fundamental guarantee of the Pretrial Fairness Act. Every crime is different. Every person who is arrested is different. And every person needs to be viewed individually. There are some people who, when the facts of the case are looked at, it will be clear to a judge that person should be released. There are other times when looking at the facts about the individual and the facts of the crime, the judge will decide that a person should be held. But there's no charge that just because someone is charged with that, they're mandatorily going to go to jail. And actually, that would be unconstitutional under the Illinois Constitution to have a system like that. So we don't have a system like that right now, and we won't when the Pretrial Fairness Act goes into effect. The entire focus of the Pretrial Fairness Act is really on individualized determinations about jail.
Okay. Well, I see our time is coming close to an end. I have 3 more questions that are very important to ask. One is, on January 1st of 2023, how many people detained in Winnebago County Jail will be released?
So I don't know the answer to that question because I don't know a ton about who's in Winnebago County Jail right now and why they're in there. But one of the things to note, I think that there's this idea that somehow at like 11:59 on January 1st, like all of these people are suddenly going to become eligible for release and are going to walk out the jailhouse door without ever seeing a judge. And that's not the case. If people do, and there will absolutely, and we want there to be people who under the new law will be entitled to release where previously, for example, they might have been held on a money bond. But that's going to happen through a hearing that happens in front of a judge once January comes. So it's not going to be at the kind of situation where there's some sort of immediate or automatic release of a very large number of people at the same time. Again, these determinations are going to be made individually.
Oh, okay, thank you. I think the question comes because there was an article in the newspaper by our state's attorney that indicated 400 people or so would be released on January 1st. The next question is, let's see, how did they write? So this person is looking for clarification on how the trespassing citation will work and citizens' rights. Can judges detain a person charged with a probationable offense if there is a safety or flight risk issue? That might be two questions.
Yeah, so
But,
it's complicated. So the basic answer is if there's a serious, if someone's charged with a serious crime, whether or not it's probationable, they can be detained if there's a flight risk. There's also a set of charges that's enumerated in the statute. It includes all gun charges, all domestic violence charges, all sex charges, all human trafficking charges, and then also non-probation, what we call non-probationable forcible felonies. And all of those charges are also eligible for detention for safety reasons. So one of the things to keep in mind when we think, I think one of the things that's important to keep in mind is in particular about gun cases, any charge that involves a gun, if it is essentially almost always going to be eligible under safety reasons for detention because it's in this list of enumerated offenses that are listed out in the bill. So basically the answer to that question, I'm a lawyer, so it depends. But I think that, but in general, there's the two different reasons that someone can be held.
Okay, thank you. And the last question is, someone wants to know, what does the opposition look like during the veto session?
So that's a good question. I mean, I think that what we're seeing across the state is that there are a lot of people, many of whom are not making arguments in good faith, who are opposed to this bill. I think there's a couple reasons for that. I think one is because there are people who believe that jail makes us safer, and I think that they're wrong. And the other is because change is hard. We're making a huge change to our system, and I think that there are a lot of people who are afraid of change. We can expect that during veto session, and frankly, after January 1st, and for a long time after that, we're going to face some opposition from folks who disagree with the goals of this bill. And we're seeing the beginnings of that. Really, we've been seeing the beginnings of that for a long time, but we're seeing a lot of, we're seeing a really concerted attack right now. I think the attacks during veto session are going to look very similar, and I think that we're in for the long haul. We're going to be needing to make the case that this bill is a good idea and that this bill is making us safer for a while. And I think that's fine because I think that we know that it is. I'm not worried about our ability to make that case.
Well, Sarah, we want to thank you so much on behalf of Rockford Urban Ministries and our local
one more
Winnebago
question.
County.
Matt, can you put the question that, sorry, I just saw you were, oh, thanks. Who benefits financially from the continued existence of money bond in Illinois? Who is arguing to continue this inequitable practice, and what are they saying? It's a good question. Money bond, money bond right now has often been used to fund a court system that really has been funding itself on the backs of poor people for a long time. That's sort of a very sad fact about our current court system. Because of that, I think, when I said that people are afraid of change, I think that that's one of the big manifestations of that, is the people who are involved in the court system are used to that funding stream and are afraid that it will get cut off. There has been a study by the Civic Federation that shows that the actual impact may not be that big. The counties keep 10% of bails that are posted, and the actual amount of revenue from that in comparison to county budgets is not huge, but there will be an impact. And I think that I think that we need to keep that in mind and pay attention to what the funding needs of our courts are going forward. But that's really what I mean when I say that change is hard. This is one of the ways that that changing the way we the way that we make our pretrial decisions is going to mean changing the ways that we pay attention to how we fund our courts. But fundamentally, we shouldn't be funding our courts on the backs of poor people. We shouldn't be funding our courts by asking people to pay ransom for their loved one's freedom. It's not right. And ultimately, we need to have a better system. And now I'm done. Sorry, Dorothy, I interrupted you.
No problem, no problem. I was just trying to keep us true to time, but that was a very important question, and I'm glad it was asked. And again, on behalf of Rockford Urban Ministries, our executive director, and our board of directors, we're very grateful for the time that you have dedicated to working on this bill and this legislation, rather, and for this fight. We know that it's not just about legislation, but it's about the lives of individuals. And that's one thing that we want to keep in the forefront, is that people's lives matter, and they need to have the opportunity to recover and to have fairness and justice. And so thank you so much. We're looking forward to future presentations with you. And if we can somehow be of assistance to you, please call on us and we'll be there. So have a great and blessed evening.
Thank you all so much. Bye now.
Good night.